Americans.
Good morning, and it's Update Friday. This is CJ, your host for Weekdays Live and founder of Homeowners for Justice. And that is what we're going to get. Justice for the homeowners. I won't rest till we do, as you all know. Today, we've got information from all over the place. It's really cool. And I just want to let you know that we're frantic at the last minutes because people are saying, oh, I want to be. And I'm saying, send me pictures. So today we're short a couple of pictures of some people. We're not sure if we can get them on, but if not, I'm going to bring you up to date on what's going on with in every corner of our nation. So interestingly enough, we're also going to show some news. And then I do want to take a few minutes at the end of the show to start to really help us all laser focus on the solutions, because that's what we do here. We develop solutions. We're going to stop these foreclosures, keep people in their homes, and get justice and restitution. So, without further ado, I want to just quickly mention a couple of things that are coming. There's a rally going to be held in San Bernardino County on March 15, the Ides of March, so that's about a month away. And it's protesting illegal foreclosures. They plan to rally in front of the recorder's office. I hope we can hear a little bit more about that today. If not, we'll be having that in the next couple of weeks so that you know who to contact if you want to get involved with that. And this is not a bad idea. What if we made this a nationwide rally on the Ides of March? Every county, activists everywhere, rallied in front of the recorder's offices. It was last year that Tim Nunn down in Petaluma had that idea. This is a crime scene. It was his idea. And that was a pretty big event last year. So let's try to make it bigger this year. That's my goal. And I also wanted to mention, please, I'm getting, and I don't blame you, but I'm getting dozens of emails. I'm now utterly swamped. I probably can't return your email for your specific counseling of what's going on. And so I will commit, and I'm hoping this weekend and Monday. Monday's a holiday. I'm not going to do a weekday live on Monday, but I'm going to start doing some training sessions so that when people, have questions, and I'll link them to the web page so they can follow the live stream. It's archived. They can just listen to the training session, and hopefully that will be enough to really get people off the ground understanding what they need to do. Because it turns out some people know a lot and most people know nothing, and they don't even know what the documents are. So I'm going to try to make, a few straightforward, relatively short, but complete and comprehensive sessions about what these documents mean and how we're going to use them and what we plan to do and how we're using the things that we find, the faults and fakeness of these documents, how we're using that to help stop foreclosures. So that's coming. I just wanted to give you an update for that. So what we really want to see, and I want to put this up here again because this is the point. The point is not just a big discussion, and it's not just sharing all of our agony. We're all in agony. So the point is we want to get the solution, and the solution is going to come both with deep level groundwork and high level media attention. So these folks, the ones on the screen right now, these are high level. They've got media attention. If they go out and do something, media notices. So let's do everything we can to connect with them. Elizabeth Warren, William Black, Neil Barofsky, any other Democratic or Republican, it doesn't matter, remember? We don't care if it's a D or R. We care if they care about the people against the banks. So Sherrod Brown in Ohio, Chuck Grassley in Iowa, and anybody else that is one of our legislators that is on the side of the people, let us know. Share it with the group. We'll share it out on live stream. And the local Democracy Now! Groups, whatever they call themselves, Again, it's not that important what their name is. What is important is what are they fighting for, and will they be good partners for the people in the efforts that we're doing in stopping fraud on a massive scale. by the banks and the corrupt legislators and government officials that they've bought off. So help me. I get emails all the time. Everybody sends me an email, says, oh, have you thought of Elizabeth Warren? No kidding. I've already gone to her website. Others have called her. That's not good enough. It's not working. We're not connected. So please don't tell me. Please tell them and get us connected. Help us connect. That's what we need. I need your help. I can't do it. I don't have a direct connection with these people yet. Help us get a direct connection. So without further ado, you gotta watch Elizabeth. She's my hero. This is really, really great. She's embarrassing the hapless bank regulators, and this is just the first hearing. Now, come on, guys. We've got to connect with her, and we've got to make a huge media effort about her efforts, and we can back her up by collecting millions of owners. That's what's going to take. Million owners, boots on the ground. Listen to this.
Thank you very much, Mr. Chairman. Thank you, Ranking Member. It's good to be here. And thank you all for appearing. I sat where you sat. It's harder than it looks, so I appreciate your being here. I want to ask a question about supervising big banks when they break the law, including the mortgage foreclosures, but others as well. You know, we all understand why settlements are important, that trials are expensive and we can't dedicate huge resources to them. But we also understand that if a party is unwilling to go to trial, either because they're too timid or because they lack resources, that the consequence is they have a lot less leverage in all the settlements that occur. Now, I know there have been some landmark settlements, but we face some very special issues with big financial institutions. If they can break the law and drag in billions in profits, and then turn around and settle, paying out of those profits, they don't have much incentive to follow the law. It's also the case that every time there's a settlement and not a trial, it means that we didn't have those days and days and days of testimony about what those financial institutions had been up to. So the question I really want to ask is about how tough you are, about how much leverage you really have in these settlements. And what I'd like to know is, tell me a little bit about the last few times you've taken the biggest financial institutions on Wall Street all the way to a trial. Anybody? Chairman Curry?
To offer my perspective,
sure.
A bank supervisor, we primarily view the tools that we have as mechanisms for correcting deficiencies. The primary motive for our enforcement actions is really to identify the problem and then demand a solution to it on an ongoing basis.
That's right. And then you set a price for that. I'm sorry to interrupt, but I just want to move this along. It's effectively a settlement. And what I'm asking is, when did you last take, and I know you haven't been there forever, so I'm really asking about the OCC, a large financial institution, a Wall Street bank, to trial?
The institutions I supervise, national banks and federal thrifts, we've actually had a fairly fair number of consent orders. We do not have to bring people to in a trial or an
Well, I appreciate that you say you don't have to bring them to trial. My question is, when did you bring them to trial?
We have not had to do it as a practical matter to achieve our supervisory goals.
Ms. Walter?
Thank you, Senator. As you know, among our remedies are penalties, but the penalties we can get are limited, and we actually have asked for additional authority, my predecessor did, to raise penalties. When we look at these issues, and we truly believe that we have a very vigorous enforcement program, we look at the distinction between what we could get if we go to trial and what we could get if we don't.
I appreciate that. That's what everybody does. And so the question I'm really asking is, can you identify when you last took the Wall Street banks to trial?
I will have to get back to you with the specific information, but we do litigate, and we do have settlements that are either rejected by the commission or not put forward for.
Okay, we've got multiple people here. Anyone else want to tell me about the last time you took a Wall Street bank to trial? You know, I just want to note on this. There are district attorneys and U.S. attorneys who are out there every day squeezing ordinary citizens on sometimes very thin grounds and taking them to trial in order to make an example, as they put it. I'm really concerned that too big to fail has become too big for trial. That just seems wrong to me.
No
E-Trade
kidding.
technology.
No kidding. That is completely wrong, and we must change that. Now, during this video, I've already gotten some information, some emails back from people that are watching. Thank you so much. And come on, guys, let's get a connection. Because I'll tell you one thing, Elizabeth Warren is in front. She's a senator. She's now able to actually spearhead this kind of an investigation. What if, just think about it, what if she had 100,000 owners? What if we were all there standing behind her? What if we were packing Washington, D.C. saying, you guys do something? Did you hear the OCC regulators? Oh, we've done the best we can. It's vigorous. It's vigorous, my hind foot. The vigor that they are doing is, I got an idea. Let's let the banks decide how they, the foxes. Let's let the foxes decide how many chickens they've eaten and what they should be penalized for it. And just like Elizabeth said, I so admire her. I would be so outraged. She's so nice and calm. It's so great to, skewer them calmly. But the fact of the matter is, as we've said before, the cost of doing fraud, it's just a tax. It's just simply a tax on that business, and we must change that. Here is something that I would like to share. This is another from Pennsylvania, a lawsuit. We've heard about the Pennsylvania County Recorder has been suing MERS, and the first lawsuit she had was evidently dismissed. But in that lawsuit, she heard about quiet title action. And if you've been watching the live streams, what's so wonderful on the live streams is that I'm doing them so I hear all this information. I'm like watching them all. And John, just a couple of days ago, John Stewart, talked about presumption, which made such sense to me, and why so many people, owners, tend to be failing in lawsuits. And that is because once a document is recorded on the property, like a foreclosure document, it is presumed to be accurate. And there is no real way in fighting a foreclosure lawsuit to actually bring those documents in and say, hey, Your Honor, they're fake and false. That doesn't count. They're presumed to be accurate. Now, in quiet title action, nothing is presumed. Okay? So in quiet title, the Pennsylvania County Court went back and sued MERS in quiet title. And the fact is that MERS has no presumption of accurate documents. They have to now prove that those documents are correct. And so it's a fair fighting ground, a better fighting levels the playing field. And so that is what we need to do, and that's what John was talking about, and that's even what Rob was talking about yesterday. He wrote the notary complaint book, and he's been in court, and the facts are these. It just dovetails into our laser focus that we're really forcing to look. Everybody should look right down at the documents, and this is the double-edged sword. They are recorded on our property. So even if they've been used in the past to take away a house in foreclosure, they're still there. And those owners are learning real quick that they can go back, get those documents, and start using them to show they were fake, they were forged, they're false notarizations. And I'm going to go down the quick list of what we've included in the statement of suspicious documents. I'll probably do a training session on that. But whatever time we have today, at the end of the show, I'm going to talk about that and emphasize the kinds of documents and what you really need to look at, because you don't need to look at everything. We just need to focus on the ones that count. So, without further ado, this is the point. This is a quiet title action. This is all about the documents. And this is where the owners can get justice and restitution. I'd like to welcome on the show a person from Hawaii. I think her name is Mish. Are you on the air?
Yes, I am.
Thank you. And Mish, that's all. Is that what we call you? Is there a better name that you'd prefer?
No, I prefer Mish.
Okay, so here's Mish from Hawaii. She's a retired school teacher. I just heard about her about 15 minutes before the show. So introduce yourself. Tell us what you've been doing, a little bit about your background, and what it is you're bringing to the show to update our listeners with today.
Well, I'm bringing about maybe 18 full years of researching different matters, and it all kind of culminated and led up to the mortgage industry. After 21 years of teaching high school, I actually didn't retire. I just kind of stepped out of the classroom, which I thought was just going to be for about a year, turned into about 3 years right now. And my classroom just changed. The walls are just not there anymore, and my students are a little older than my high schooler students. And what I've discovered is, I'm not sure if anybody's familiar with the book Modern Money Mechanics, but I was, over the years, as a teacher, been able to talk to different people, and I've met people from all walks of life, and the ones that have become more dear to me, only because of what I'm gleaning from them, are two people that actually worked for one of the bigger local banks here in Hawaii and for another bigger bank on the mainland. And they began to share with me what actually happened to those mortgage notes. And as a result of that, it turned out to be that, I found out, certain things you just begin learning, and then I started to apply those lessons I was learning. And as a result, I've been seeing, and this, I'm not an attorney, I don't want to be one. However, I know how to, and I've seen just in the past 3 months, foreclosure was actually reversed. I also have, as the most recent, on January 30th, receiving a letter as in a response to the qualified written request, and it was a loan that was canceled. So these are the things that I'm working with right now. My bucket at work. Okay. Okay, and I'm sorry, I'm trying to get out the door at the same time. So that kind of gives you an idea of what I've been doing. Been able to help not just stave off, but in one particular case, and I'm going to send you that document as well. The mortgage, sorry, I'm trying to gather my thoughts as I'm speaking. The foreclosure was actually dismissed by the bank, and this is Bank of America. So my heart right now is to try to locate those 30,000 people that they've already pegged. Bank of America has already released and said, and this is through some people who I have on the inside, 30,000 homeowners right here in Hawaii are going to be foreclosed upon.
Exactly. And Mish, we've got almost 100,000 people in California, families, right now facing foreclosure auction. It's just an outrage.
There's a gentleman that he worked for First Hawaiian Bank. I just got through talking to him just before I was speaking with you, and he says, Mish, we think the mess is bad here in Hawaii. It's almost at an astronomical rate worse in California. And unless we help people get educated, and unless people get educated, it's just not going to happen for many. For many, they just get the notice of default acceleration to accelerate the mortgage, and you got people packing up and leaving their houses. And that's what led me to looking into the Bureau of Conveyance a little more closely and looking at homeowners' mortgages. Because number one, I know that every one of us on this call, we are not looking for something for free. But we also were not looking at or did not even suspect that someone else got something for free, like 10 of those houses the same day at closing. So that wasn't something that was it was their situation turned into a nightmare to a point that they were going to lose their homes. And all we did was pull together, a bunch of people who knew what was going on. And then I found out that there are some, the situations are so awkward and unique that they have to go to a law firm. Well, the next problem was finding an actual law firm that was out there for the homeowners, because in Hawaii, the vast majority of all the attorneys here have been paid off by those big banks. They were all dropped off a little, here's some money to get started, and you're going to go ahead and foreclose on X number of people.
Exactly.
Well, thank God that we've got people, a few people here that are rather honest, and I was able to get a hold of a document and use this one law that they put into effect about a year ago here, where the attorney has to actually sign an affirmation under the pains and penalties of perjury, and saying that they have first-hand knowledge that the servicer or the bank that they're representing has in possession the original documents at closing. And you and I both know those documents don't even exist.
Exactly. So we call that, for everyone watching, we've been terming that the affidavit of authority. And Mish, they have to sign that when they file a notice of default. Is that the point? When do they have to sign that?
I'm sorry, what was your question?
When does the attorney have to sign and fill out that affidavit? When he files a notice of default?
The minute the homeowner receives the complaint.
Okay.
I'm a document preparer, so just so you know that. In the answer to the complaint, that's where the homeowner, which is representing themselves, because I helped them prepare it for them.
Right.
They demand that of the attorney. There's an attorney here in Hawaii. He's a family attorney. He does the majority of the divorces here. He jumped on and started to foreclose on people. Well, he got it. He got that letter. I'm in court with the homeowner, and the attorney removes himself from the case. He goes, I'm not signing no affirmation. Now, mind you, they will continue doing this unless they're told that they need to sign that affirmation.
Right.
But when you challenge them, that's the thing that homeowners, I want to help them understand, is they just simply need to challenge it. Now, if in the end we find out, hey, somebody actually loaned you money, of course you're going to pay it back.
Right.
But if we find out that nobody loaned any money and you created that money off of your signature, I'm sorry, but there's something really wrong with this system. And to be honest with you, I don't think a whole lot of people are going to stand up and do this, because it does sound kind of like way out there. But they are not signing the affirmations here. And the ones who are signing it, I'm looking at a continuance in court right now going on 9 months.
Exactly. And see, in Nevada, which is a non-judicial state, they have to sign that affidavit of authority, that affirmation that you've talked about, and submit that with the notice of default. And the attorneys just aren't going to do it, because the attorneys do know they do not have these documents, and they're not going to lose their license or go to prison or get penalized for that.
The attorney that we're using here found a little twist on the notice of default, because they were giving people 30 days to cure. The law in the state of Hawaii, and I'm not sure what it is everywhere else just yet, but it's 90 days.
Normally it's 90 days.
26 cases in the past 3 months that have been overturned here in Hawaii.
Oh,
but
that's
can you
great.
imagine that? Even if I said 30, I've got hundreds of people that we're working with. How many of them do you think will slip through this court system's hands? And I'm watching them kick people out of their homes. I go to the sheriffs when they're doing this, and I said, hey, do you guys have any idea what's going on here? No, we're just hard to do our job.
Absolutely.
Great. And I'm looking at the homeowner, and I realize, and I ask them certain questions. The unfortunate thing is people don't realize when we're sent a letter in the mail, that's simply a contract. You're going to agree or disagree with it. So I've been teaching people how to answer it. And every single complaint, every single letter that comes from either the attorneys or from the servicing companies that we have responded to. So I tell them, I said, look, they're giving you 20 days to respond. Let's respond in 20 days. We respond, and I'm noticing that these people, their foreclosures are either at a stall right now, and I'm literally just praying and asking God to send us that answer. There is no one answer, but I like what you just said about that affidavit. Unless they have it, it's not happening.
Yes. Yes. Oh, thank you so much. And really, Mish, we really hope that you will follow along with the kind of effort we're doing, because it is all in the documents. And the facts are these: they don't have the authority to foreclose. They're just steamrolling and taking the property, and unless the owner fights back, they're still doing it. And so our focus...
Bullying tactic. It's a bullying tactic
Absolutely.
by the banksters.
Absolutely.
And, that QWR that I sent you
Yes.
and that cancellation,
Yes.
I'm going to send you a couple of more documents
Okay.
as a result of that QWR. You can share that QWR with whoever you deem
Thank you.
worthy.
Thank you.
And I've been doing it not in, because I have hundreds of people I'm working with. So
Right.
I took the most critical cases, and I do just a few a week, not more than 10 a week, because I don't want the banks to try to change the system. And if you read that QWR, very different, very blunt, the way it was designed. And what I'm getting is, number one, last night I got a loan that was charged off. Today, January 30th, I got the cancellation of the loan. About 4 weeks ago, I'm going to send you this document from Bank of America, letting the attorney know here in Hawaii to go ahead and dismiss the foreclosure, the complaint for foreclosure, because Bank of America took the house out of foreclosure. Now, all I'm asking for is just give me those documents. You prove
Right.
that you have right standing, Rule 12b-6.
Right.
Prove you have right standing. Hey, if you do, we'll pay you. So what the law firm here that I'm working with, who actually moved here from Chicago, what they're finding out is if the servicing company does not have standing, and the one who does have standing doesn't step forth, the mortgage is a wash.
That's right. That's
you
right.
know that this isn't going to get into the local media. I don't even want it to, and I like this forum that you have. So I'm very grateful, and I can tell you that I'm looking forward to spending a little bit more time with you, either on the phone or I fly there to sit and chat with you guys, because we need to come to a head to help as many people as we possibly can.
Absolutely. And Mish, next week on Monday, my internet tech guy is coming, and I should be having 10 times faster internet. So what I'm really wanting to encourage everybody is to get on Skype, get a webcam. They're only 20 or 30 bucks. That way you can Skype in and we can have a face-to-face discussion and live stream it out there. So
I look forward to that. I'm on
That'd be
Skype. I
great.
already have my computer's built-in camera, so I'm ready to go.
Perfect. Thanks so much, Mish, for this. We'll let you get on your way. I know that you've just crammed this in here at the last minute. We so appreciate it. And we will take your information. I will get it up on the website, and then we'll let everybody know where it is. And then we'll live stream and Skype about that so that people can
Thank you
really
so
use
much.
it.
You guys have an awesome day. Aloha.
Thank you. Aloha. Hi, Mary. This is CJ.
Okay.
Okay, so this is Mary. So we're just jumped from Hawaii to North Carolina. And Mary, I don't have your picture up, but I know you sent me one, so I'm going to get it while you share with us what is going on.
Okay. Well, we've got some things really stirred up. We're getting ready to out a letter to our local clerk of court, and we're basically wanting her out of office. If she's not going to sit down and talk with us and conform to the law as it's written in North Carolina, she doesn't need to be in her office. So that letter's done, just waiting for all the signatures to get on it, and it's going. We are working on it legislatively, and that's going very positive at this point. We just heard a couple of days ago that our senator is on it, and he's finding what we need him to find, so he thinks he can move ahead with some legislation of some sort. So that's very, very positive. And we have now an attorney on board. He wants to run for the office of clerk of court. So he says, okay, you guys help me and I'll help you. So he's taken some of our cases pro bono. And we've got a situation right now, and this is interesting, so I'll tell you real quickly. We have a situation that's a land home, mobile home package deal. And the trustee, Brock and Scott, just discovered that there's an outstanding lien on the property from the original lender, which is only it's not a real estate lien, it is just a, unsecured lien. So Brock and Scott is wanting this guy to sign a release get it off the books. And of course, my guy's saying, when what freezes over. So our attorney is going to take it and challenge their right to even foreclose.
So how is this, if this sets would this set a precedent then? Is that what you're saying?
It set a precedent, but it would put, we don't think that Bank of America will go forward with pushing this deal because they threatened to sue him if he does not sign the release. Now, if they sue him, that means we go to court, and the pressure is going to be on Bank of America to prove that they actually loaned Eric any money.
Yes. Now, how are they going to prove that?
They can't.
Because
They cannot.
And what you're referring to now is exactly what we heard Mish talk about. Can
Yes,
you explain?
That was fascinating. I want to get more on what she's got.
That
was a great conversation.
Yeah,
So
exactly.
That's exactly right. And, the point is, with all of these foreclosures, and the majority of them are Bank of America, City Mortgage, Chase, and Wells Fargo,
Yeah, the Mega 5.
they're just servicers.
That's correct.
They have no dog in this fight. They have no financial interest whatsoever. And that's what we got to get across to everybody. And when Neil Garfield says deny and discover, that's exactly what he means. You have to deny that they ever loaned you any money. You have to deny that you signed those documents that the court puts in front of you at your hearing because you don't know if they're real or not.
And I totally agree. And I have up on the screen right now for people to look at, and we will be discussing this in my live stream training. And this is some of the law that I've collected and we're quoting in the statement of suspicious documents. And what I've got is number 11. It's 15 USC United States Code 1641 F1. A servicer. So all of these banks are master servicers. We constantly refer to them as a servicer. Let's keep, the more clearly we speak, the more easy it is to understand because we've actually made it more clear of the parts everybody is playing. So this code actually says a servicer of a consumer obligation arising from a consumer credit transaction shall not be treated as an assignee of such obligation for purposes of this section unless the servicer is or was the owner of the obligation. So one of the easiest things to see on the face of these documents, that's why I say we got to laser focus on exactly what are they saying on these documents that they record and take the houses with. And is it on the face of it, is it either an illegality or an impossibility? So this is a classic illegality where MERS assigns it to the servicer.
Right.
That they were never the owner of the obligation.
Never. And I got a chance this weekend to read the state of Kentucky, the AG's lawsuit against MERS, and that's a very, very informative lawsuit because it spells out the consent order that MERS agreed to back in July of 2010 not to foreclose in the name of MERS. And they were forced to do that in the courts. So I'm using that information in what I'm doing, in the documents I'm doing. I absolutely think is our champion right now. We need to let her know we appreciate what she's doing. To come out like she did in the hearing just yesterday.
Absolutely.
And say, how many cases have you taken to court, guys? How many?
Oh, I know it.
There aren't any, basically.
Oh,
so
just nail them.
Things we have to support and let our politicians know we appreciate that.
Absolutely.
Because she was knocked out of a job. She was knocked down in Massachusetts, and she's coming back fighting like crazy.
Well, and see, this is what's happened. Guess every one of these people, I'm going to bring up those folks we need to connect with again and bring up that screen. Every one of these people that were in government, involved at the federal level, they cared about the people. Are they working there now?
Oh,
No. They've been booted out.
Right.
This is the
I
point.
think she's right on point on what she's doing. One other thing that I did, I have a case that there's a divorce situation, and because it is a divorce situation and the actual promissory note was just in the name of the husband, they're refusing to give us information that we need to move forward.
Right.
However, I sat down this weekend and I went through her file, which is not much there at all, but I was able to find in the assignment, the corporate assignment of the deed of trust, lots of things that point to fraud. You had a notary in one state, you had a signer in one state. All the things that Matt Weiner told us to look for fraud, they were there.
Right.
So
right.
even in the simplest of files that you've got, there's probably some strong evidence of fraud just in what you've got. So now the next move will be to sit down and write a letter to that trustee and say, here's what we've got, guys. Now, if you want to move forward with this, then, you're putting your license on the line for committing fraud because you're perpetuating the fraud. So it's not just going after the clerk of court. We're going to go after these foreclosure mills again.
Exactly. And just as a real quick update, and I don't want to emphasize it too much, but we're already in discussions now with prosecutors that are actually interested in doing after some criminal charges, because this is the point. It's a criminal conspiracy. Louisiana's tried, a lawsuit. I don't even know the update of where that is. When they last year started a RICO lawsuit against MERS and all the banks because it is a criminal conspiracy. I have up on the screen right now, because what she's mentioned is exactly what we're going to show. And this is why it is so crucial, and why the statement of suspicious documents, we identify these specific issues that are wrong. Here's something just on the face. When you look at the document, I've got those 15 pages of Lauren Stone. It's linked to the website. It's what I've collected so far that I've actually been able to scan, and I have a stack of more documents, and I apologize. I'll get it done this weekend. But nevertheless, what you see here, just take a look at it. This is a corporation assignment, okay? And for value received, the undersigned gives this beneficial interest to City Mortgage. But look at the undersigned.
Yeah.
It's Countrywide Home Loans.
Lauren Stone.
Well, and look when they filed it. They filed this just less than a year ago in April 2012. So on the face of it, that's insane. It's an impossibility. Countrywide Home Loans has been defunct for years.
I know. I found another one. I think it's the same case where I had mentioned before that there's a lobbyist for one of these foreclosure mills who is signing documents on behalf of this New York Mellon Trust, and he's signing the corporate deed of trust, the corporate assignment of trust, as if he has the authority to do that.
Right.
Now, do you think I'm not going after him?
Right, exactly. Now, see, what Mary's talking about is going into even more depth in does that person actually have that authority to do that signature? Where we're focused is really the simple stuff, just because I think we can still major trip them up with this. And
here's the point that I think I need to make.
Yeah, go ahead.
Everybody understands this too. If you can get your hands on any of the pooling and service agreements, which I've gotten my hands on a couple of them so far,
Yep.
they do not give anybody, and that's anybody, the authority to sign anything on their behalf.
Right.
And there's a reason for that, because they are written under the New York trust laws for the most part. They are the Massachusetts trust. The trust laws are very strict, and if they're
Exactly.
violated, then you lose your REMIC status.
Right.
So they don't allow anybody to do anything for them because it's gonna violate that REMIC status that they have, and then they got big problems with the IRS supposedly. Of course, we know the IRS isn't coming after them anyway, but that's a big issue. So if you see somebody sign any kind of a document like this corporate assignment of deed of trust, and it's signed on behalf of a trust, a mortgage-backed security, it is bogus.
Right,
It's
right,
bogus.
exactly. And in fact, on Lauren's, and I was actually trying to discuss this with some of these prosecutors, and they do not understand it.
No,
they don't. And
It's a big education
Yeah.
gap. The attorney that we've got on working with us now, we grilled him pretty bad Friday night, gave him a lot of information, gave him some case law to read, which he
Right.
understood.
Right.
But he's still got a lot to learn, because when he was talking to Eric yesterday on the phone, he said, how far are you behind in your payments? And I said, Eric, tell him it's irrelevant. That is not.
Exactly. And that is the answer. And this is what I've said to people, because when I'm now talking, Jed got me over there in Mendocino County. Oh, I forgot. I'll give you an update on that real quick after Mary. Too many things. The fact is, we're talking to the people in the DA's office in Mendocino County, and up comes the what I call the standard reasoning, and that is step 1, 2, 3. Did you borrow the money? Yes. Or have you stopped making payments? Yes. Then you should lose the house.
Right.
End. Concluded. And the answer is, and this is because I've been struggling to come up with, how do you explain this? Because first off, as we're learning, it wasn't real money. When you signed, they created credit at the Federal Reserve. So you just created that out of thin air. The second thing, though, is it was never the bank's involvement. It was never, they don't have, like she said, no dog in this fight. They don't have any money. It was never theirs. And they put those payment streams into the mortgage-backed securities. And when a payment defaults 60 days, that's when insurance pays the mortgage-backed security. It triggers the insurance payment. That's why they always tell you, 60 days. And
right, because they're trying to trap you into that 60-day period
exactly.
so that they can file a claim to get reimbursed for the insurance.
Exactly. So here's the point that I said to these staff people of DA's office. I said, let's say you, the man, paid off your son's car loan. So it's paid. Mm-hmm. Or should that car get repossessed? And I'll tell you, that really stopped him. Because that's a simplified, very simple, and there's a whole lot of stuff that's left out. But at this point, we need something simple that we can use to block that kind of mentality. And James McGuire, in fact, here's another update for next week. McGuire and Alvy, they're planning to, I'm going to update my internet. They're going to Skype in, and we're going to have a Q&A session, a discussion about some of these issues, because James has been talking to some of the legal professors, and the legal law professors don't understand this either. And,
no.
And if they don't understand it, how in the world can we expect our prosecutor attorneys to understand it? That is the point.
Let me make one point about we had a presentation about an economics law professor at one of our meetings this month, and he was talking about the economy and everything going on, and asking some pretty pointed questions. But you got to understand, these economists, they are big investors in the market.
Yeah.
They don't, they're still looking for trends and things to happen that aren't going to happen because this is not normal business.
Right.
So they're still looking for something that doesn't exist anymore.
Yeah.
So for them to understand about a fractionalized banking system and what that really means, they don't grasp it. They don't understand that no money was ever loaned yet. They're not even there yet. The economists aren't there. Now, they might be and they're not telling us, but I don't believe they're even there yet. Because when we were asking this guy, and he's a professor at Elon College here in North Carolina,
right.
And I was trying to explain to him about the derivatives and well, he knows about derivatives, but the impact that they're having, that they're not real, the mortgage-backed securities aren't real, there's nothing there. He wasn't really to accept that because he knows he's invested in them.
Exactly. And that is why I'm talking to people occasionally and try to get this out. I'm going to say it now so that we can all be thinking about how do we resolve this, because we're going to get a whole lot of people not wanting to understand or listen or prosecute or proceed because of the fear that this will collapse. And if that collapses, how's that going to hurt me? So we need to figure out how we can sell the resolution that doesn't hurt the people but puts the punishment exactly where it belongs. And then people will be much more willing to cooperate.
Yes, they will. And you're absolutely right.
And now I have up on the screen something I just wanted to point out to you, Mary, because Mary had said if you pull up the PSAs, the pooling and servicing agreements, and so here's the corporation assignment. Another one of the Lawrence Stone. It's just so classic. Just those 15 signatures of Lawrence Stone just violates everything on the face of the documents that are relatively easy to understand. In this case, it was another corporation assignment, and this was for value received. The undersigned, which is Bank of America, is the quote undersigned, gives to the beneficial interest to U.S. Bank National Association as trustee for CSMC Mortgage Loan Trust 2007-3.
And that's about as forged, that's a forged document because the PSAs do not allow anybody to do that.
Thank you, Mary. That's exactly that's what Linda told me, because I'm saying, okay, now I understand that this isn't right. How is that? She goes, a bank can't do that.
That's right.
And see, I said that to the prosecutors, and they go, "What?" And there you go. There you go. I swear we are going to simplify it. My goal is to simplify this so that your junior high kid can go, well, duh. I can understand
many
that.
good case law decisions that you can find. That's helped this attorney here, and because he read one here in North Carolina, he says, "Oh, I get it, sort of," but he's still not there. But he said
Right.
that case was right on point. It spelled out what was happening with the notes and why the courts could not allow them to go through because they weren't properly assigned.
Right.
So he
And
understands that part of it now, but we still got a big educational process to go through.
Absolutely, because again, and I'm making it my mission every live stream, somewhere in the live stream, we've got to point out that what we're talking about, this fight that we've got on board, that, you know, the foreclosures and the fraud, that is just a symptom. It's not the disease. The disease.
Referring everybody that I know to your website because it is so full of good information.
The disease.
And actually sent that to the attorney this morning.
Oh, thank you. And the disease is the money. It is all about the money. It really is.
It is.
Because it's the facts are these. Private bankers think Chase and Citi own the Federal Reserve.
Mm-hmm.
Every time the Federal Reserve creates credit, guess who gets paid?
Mm-hmm.
They get paid. Guess who owes them money for interest on that money? And that's you and me. That's everybody else on the planet.
If you can get the message across to the DAs that the only people that have made money in these deals are the banks.
Exact, and they're making it hand over fist. Besides, they're just simply going to the Federal Reserve and creating trillions of dollars. I had a little video. I thought it was so classic when the Federal Reserve people are put on the hot seat and said, okay, so what happened? Where did those $1 trillion go that you just you sent out the last few months? And they don't know.
And they're trying to do it again. They're trying to do it again right now.
They will continue to do it. Period. Because there's no audit, they have no one over them. They just literally will create whatever they need and want.
Well, I think this is the time to give Elizabeth Warren all the ammunition she needs.
I agree. And so literally,
Go girl, get it done. We're right behind you.
Absolutely.
And if you need any more proof of fraud, just let us know.
Absolutely. And I'm telling you, if we can get national attention to these, to us, our group.
Oh, our article did come out in the paper last week. I forgot to tell you.
Oh.
Because, I had mentioned before the article that we were doing on foreclosure, so it actually came out in the article last week, in the paper last week. And it was very good. It was more of a human interest story because it touched on two people that were losing their homes, the money they invested over the years, and the fight that they were having to go through to keep their properties. But the point was that we are winning, that we have stopped the foreclosures, and that we're just getting started good. So that much is good. So we'll see. I'm going to do some more articles or letters to the editor to follow up on that, and see if we can't make more headway that way.
Mary, can you do us a really big favor?
Okay.
Okay, obviously whatever she's writing is working. So let's copy. I'm always into copy.
Okay, what's wrong? Don't have the article?
Well, can you send me the article? I'll
Okay.
post it and send us these sample letters to the editor. Because if she's writing these things, then we don't have to create them. All we need to do is take them and send them to our editors. Can we do that? Would you let us, take what you're writing? We'd pull out information, perhaps, if you have included about North Carolina, because it's going to be true in every county.
Absolutely, because absolutely,
Yeah,
I can do
yeah.
that. So I'm going to draft one this weekend maybe, and get it going, and we're going to get our letter going to the clerk of court. I'll send you that after I mail it out.
Thank
because
you.
It's very sensitive. I don't want that to get out before
Yeah, that's
she gets
fine.
it.
Oh, that's
and
fine.
I'm actually sending a copy of it to the assistant clerk because her job is on the line too. Because they actually refused to give us a copy of the foreclosure hearings calendar.
Right, I remember that.
Serving.
I remember that. And that's not legal. And why would they do that?
No, that is illegal. That is in violation of the Public Records Act here in North Carolina, I think all over the country.
And why would they do
so
that?
I'm bringing them task on it.
Why would they do that, knowing it's illegal?
Because, this clerk thinks she's on the pedestal. She doesn't really care. She's marking time till she retires, and she doesn't want us there nosing in on what she is trying to protect. So
Right.
the idea,
Right.
but to get that calendar, was to be able to sit on the hearings and monitor what she's doing. She doesn't want us
Right.
there.
Right.
And
Right.
the calendar I could have used to contact other people, those people, to let them know we can help.
Exactly, exactly. And see, we've talked about mailing lists. Some people mailed. In fact, I want to update you in just a couple of minutes about Mendocino County because people actually showed up because of the mailing. I mean, the mailing works, but it's fairly expensive with postal.
And a lot of people ignore the mailings because
Yes.
they think it's just another,
Yes,
I could do a short sale or something like that.
exactly.
So
They
that's
don't
why I'm
know.
trying to find a more direct route for, public knowledge or whatever to get to these people. So there'll be more of that. We had one publication here that wouldn't even print the article.
That I'm not surprised with.
So yeah,
I'm not surprised at
they,
all.
They didn't wouldn't do it, but he's the one that gets to publish all the foreclosure notices. So this is a source of
Right.
revenue for him.
Right. See, there's you got to look at
Yeah.
which side might they be on because if you're jeopardizing their income,
Oh yeah,
they're gonna fight you.
Absolutely.
So somehow we think about that, and maybe we can address that. I don't know how, but come up with ideas and let's share them. Thank you so much for sharing this, Mary. This is just keep us posted, and we really look forward to those letters to the editor, any articles that have been printed. If you could share those too, because if there's an article being printed somewhere in the country,
Yeah.
let's share that article with our local newspapers.
I'll get you a
Maybe,
copy of it.
thank you. Maybe somebody will keep printing because the more we get it out in the news,
Yeah,
the more people are going to go, well, wait a minute.
yeah.
Maybe I could save my house.
Yeah, maybe
There's
I
a
could sell
thought.
more papers if I put the truth out there. How about that?
Exactly.
I know. All right, keep up the good work.
All right. Thanks so much, Mary. We'll talk to you soon. And so what I wanted to do is update quickly about Mendocino County. We met with Jed. This is Jed. Jed is, and I've been teasing him, saying to Jed, okay, when this completely breaks open and we have the banks on trial with criminal charges, they'll settle. They're not going to go to trial probably, but they'll be sued. It's going to be your fault because what Jed has done is actually pushed me to the max and has gotten the first actual statement of suspicious documents, which I'm going to show you here in just a minute, the outline and review, and then this weekend I will do a training session on it. I will get it uploaded to the website. I've been sending out what I've got to people because they've been desperate and asking for it, and that's fine, but just understand that it's still in evolution, but we're real close to being done. Nevertheless, Jed did exactly the program. He got his documents. He and I looked through them. We itemized the different things on the face of each of these documents that are fake or forged. He's gotten notary signatures, journal entries. We're matching those. When he gets those back, we'll be matching those with the signatures, and that would be an update in the complaint. He made 8 copies of it, took one to the sheriff. We went to the sheriff, and the sheriff was really great and open. Jed's really good, explained what he's doing. Initially, when we started with the sheriff said, well, I'm not going to read this. But by the time we left, he said, well, I'll be reading the first 6 pages. As I was teasing Jed on the way out, you mark my words, he'll be looking at every one of those pages, because what we're actually showing is fraud and forgery on the face of the documents. When a person, an entity like the bank, like I showed earlier today, from Countrywide Home Loans, is they're assigning beneficial interest completely impossible on its face. The only reason they've gotten away with it is the owners don't understand it, and neither do the prosecuting attorneys, and neither do our officials. So we're educating them, and this is a fabulous way to educate them. So we went from the sheriff's office, who said, well, we'll take a report, and I interjected and said, so is that what we should do when there's going to be a lot of people that find out about this and want to place reports? And the sheriff sits back and goes, well, let's talk to the DA first about that. And so we're working through the process. How are we going to do this? Are you going to force us to file these police reports, or can we just go straight to the DA's office and submit these complaints? So then we went to the recorder's office, and this is the group waiting outside the recorder's office. Of course, they start asking questions. Of course, I start talking. But nevertheless, we went in and then talked to Susan Ranachek. She's a great lady, great recorder. Basically, after the group Jed made the presentation, she took the documents, she accepted them, but she made a couple of fascinating comments. And one is, when they submit those documents to be recorded, it's not fraud or forgery until they're recorded. When she stamps them, that's when they're recorded. And that's when it's a fraud and a forgery. So that was interesting. And she told me, between the two of us, because I stayed after a little bit and talked to her, because I like her a lot. I know she cares. She's just desperate to have somebody do something. She can't. It's not part of the recorder law in California. They simply must, they're required by law to record that document when it comes in and it looks filled out correctly. She has no tools, training, understanding, or authority to actually go through those documents and say what I just showed you with the Lauren Stone, that, hey, bank can't assign that to the trustee. Pfft, forged. She can't do that. But she's desperate to have that done because she and all the rest of the recorders in this state agree with what Phil Ting's audit was, and that is 84% of the foreclosures are fraudulent. They're illegal, they violated the law, and the recorders can't stop it. So I know that we're talking about a crime scene event, in March 15, and I think that's great. But let's always remember, it's not the recorders themselves. O'Brien has decided to step up. He's unusual. Most of the recorders are not going to feel like they really have or want to take that authority because they would be held liable. The banks could come after them and say you're liable. So that's one of the issues about that. The whole affidavit of authority that hasn't been required by law in California. Now it's been done in Hawaii, but that's in the complaint. So whenever a complaint is sent, it's a judicial state, and even in judicial state, owners and attorneys don't know their rights. And even in judicial states, with foreclosure defense laws, the attorneys don't want to step up and help. And I hear this all over the nation. You can't find an attorney. So here's the answer, guys. We teach ourselves. It's not that tricky. Not what we're doing here. You're not even going to court. What you're doing is going to collect the fraud and forgery on your documents, and you'll only get these documents if you've had a notice of default. So if you've not been paying your loan and you don't have a notice of default, you can go to the recorder's office all day long, but you will not find the documents I'm talking about. The ones that count, and the ones that really count are the assignment, the trustee substitution, and then the notice of default, notice of sale if it gets to that point, or trustee's deed on sale if you've already lost the house. So nevertheless, after the recorder's office here in Mendocino County, we went over to the Jed took 5 copies and dropped them off at the supervisor's office. They weren't there, so we dropped them off with the front desk. And of the complaint. So everybody now is going to have the complaint. Then we drove downtown and went to the DA's office and met with 3 of the DA's staff. And that is where they paid attention. They first want to know, okay, who in Mendocino County do we charge? Well, that's a toughie, because it's Recon Trust in this case. It's a foreclosure mill that's recording false documents in your recorder's office. But they don't exist in Mendocino County. And that's a big problem for the counties. So when you take, where are these foreclosure trust mills? And I've actually come up with the list. If I could think quickly where it is, I'd pull it up on the screen. I'll have it in my training session. The fact of the matter is 12, I've identified 12 foreclosure trustee mills that are in California. Many of them are down in San Diego County and Southern California. So those counties, DAs, could actually say, okay, this corporation in my county, I can go after them because they're in my county doing business in my county. And then, of course, they would look at just the forged documents and filings in that county. When we go to the state level, so Mendocino County said, really this is a state level issue. But they accepted the documents willingly. They have a pretty thinking out of the box type district attorney who is going to look at this, will keep in touch with us about what he thinks he can do or wants to do or should do, what owners in Mendocino County should do with their complaints. And I'm recommending, regardless of if your DA in your county can or cannot proceed themselves, let's be sure to copy them on the complaint. So Jed just had 8 copies, and that was it. He gave them to all those 8 parties. We're recommending, and we've been talking about, going to the media, and others have been sharing, like Rob shared, I think yesterday, that he's going to file his copies of his complaint. As we said, we're going to plaster the planet. He's going to send them to all the major networks, the Attorney General's office, all the county officials, and if your notary is in a different county than where you exist, then send a copy of complaint to that DA and recorder's office for sure. For example, Jed's notary is in Ventura County, I think, or LA County. So he should be taking a copy of that complaint, sending it to the DA in LA, to the recorder in LA. We're obviously going to take a copy of that and submit it to the Attorney General's office, those that are looking to maybe impanel a grand jury for criminal charges. You got to understand, this is not civil. And what Elizabeth Warren was talking about today, and talking to the OCC, all of that stuff is civil complaints. They just extract money out of them. And in my opinion, unless they take 1, 2, 3, 4, 5 years worth of profits away from them, it's just a tax. Even if it was a 50% tax, it's a tax on doing business. And like Elizabeth said, unless you get these people in lawsuits, they're just going to keep going. It's cost effective, for Pete's sake. They make money with fraud. That's why it's so important we stop them. So real quickly, I know we've run over just a little bit, but I will show you what I had up here. These are the suspicious document issues that we've identified to date, those that are relatively easy to find and prove. The false notarization of the name, some name on the document, and see, I've set this up so it's a 1-page, front page summary. You have the statement, the name, address, the date of the purchase, the master servicer, a third-party foreclosure trustee, who does the securitization trust if you can find that, and then the document list. Generally, there's only going to be 3 to 5 or 6 of these. And then whatever else you've done as an owner. Have you filed a notary complaint? Well, then let's identify that, and that'll be included as an exhibit. And then have you gotten the journal entry of these names, the signature samples? Those are from journal entries from the notary. So here are the suspicious issues. We can prove a false notarization. Either, the signature of the notary is different from the proven notary signature. The false signature of a name, there's a whole variety of signatures, or the journal entry signature does not match what's on your document. Did they assign this beneficial interest to the servicer? Is it assigned to, Bank of America, successor to BAC Home Loan Servicing? That's a servicer. And if it's assigned that way, if MERS assigned, that's totally illegal, because the servicer cannot be an assignee. Is it an impossible beneficiary designation? That means, just like we said, the B of A cannot assign to U.S. Bank National Association as trustee for, CSMC mortgage-backed securities. Impossible. And we need to educate ourselves and the attorneys and the news media. So the more we understand, and what I call, these are relatively simple things, we can grasp these, we can get them. And the laws I've quoted below on this document, they identify it. And I'm suggesting that we include those laws on every document. Every time we copy this, include those laws. There's 2 pages, because then everybody will read the law and they'll go, oh my God, really? That is the point. Fake title. Here's a key point. If your document, either the assignment or trustee substitution or the notice of default is assigned by an attorney in fact, that attorney in fact, and I've been asking Linda repeatedly, okay, are you sure? Are you positive that that attorney in fact designation can't somehow be circumvented with a corporation assignment or agreement or some kind of BS that they will draft and, create on demand if they need it? And her understanding is, and she's, a licensed securitization auditor and expert witness, and that is, if they say attorney in fact, then that attorney in the power of attorney has to be recorded either in the county where that document was recorded, so that would be in the county of the owner's property, or has to be included. And I have never, ever, ever personally seen any power of attorneys recorded with anything that has said attorney in fact. So that's a fake title. That's a lie. Here's a violation of the MBS trust cutoff date, and this is really, really simple. If you have a loan that's serviced by a mega servicer, the date of that loan, typically about 90 days after the date of your loan, that's the cutoff date of the mortgage-backed security that was created. Let's say that your loan was done in July 2006. So let's give them 6 months. So the cutoff date, let's just say, was at the end of 2006. So if your assignment is done after the year of 2006, the year of the loan that you took, or 2003, or whatever the year of the loan that you got, if this assignment, which is typically done in 7, 8, 9, 10, 11, 12, or 13, years after the cutoff date, it is obvious it's a violation of the mortgage-backed security. It's illegal. So that's easy. Here's a MERS conveyance from a defunct lender. That's like MERS saying, or countrywide home loans trying to assign something to somebody. It's a defunct lender. That's crazy, and that violates on the face. It's an impossibility. It's a fake document. MERS receiving value or assigning notes without the authority to do so. MERS says, I do this. And the fact is, there may be corporate resolutions that might support that authority. We don't know, and I'm researching this more, and maybe this is not something we can hang our hat on. But definitely, if you have any of these documents, definitely if they're recorded after April 4, 2012, that violates any of these items, then they're in contempt of court. And we've quoted that law. So I'll stop for now. I'm going to go into this again. I'm going to make a special training session on this suspicious documents. I'm going to do one for OCC complaints, one for the notary complaint, one to overview the foreclosure defense. We'll do one for the qualified written request. I will incorporate everything that these people are sending me all the time, which is so fabulous, because this is how the owners are going to fight back, keep their homes, and truly, just like everybody has been saying, it's not that they want a free house. They want some leverage to get a loan modified so they can keep the house. We want to keep the houses. That is the point. And right now, in the macro picture, never forget the whole point of this, which Catherine Austin Fitz has said. I have her on record. You can listen to it on my website because I saved that podcast. She has point blank said they talked about this at the federal level in the halls of the buildings there, that they were going to have a foreclosure crisis to take the homes and the land from the people. And they talked about that in the 1990s. So we need to understand, we do. This is a humongous decade, 20 years conspiracy. We're going to fight back, and we're going to get these properties back, because when owners keep the land, that is the basis of true democracy and freedom. Thank you. This is CJ. I'm signing off for today. Thanks so much for participating, and we'll see you on Tuesday for Weekdays Live. If I'm doing some kind of a training session over the weekend, I'll blast it out so that you'll know what's coming. But you can always watch it archive and send that archive training out to anybody and everybody you know. Let's get 1 million boots on the ground. Thanks so much for the middle of February. By the middle of March, we'll be even further. Talk to you soon. Bye.